is one that should be of very, very strong interest to any parents who have teenage children. If you don't have teenage children, it is probably interesting information. But if you do have teenage children, listening to what I have to say can definitely help you when and if the unfortunate situation happens when your child is encountered by the police. Every week, we get several calls from parents who are frantic because their child is at school and a police officer wants to talk to them. And of course, the parent asks us, can they do that? How can the police talk to my son or daughter without me there? I'm their parent. Well, thanks to Governor Brown, they still can do that, because there was a law that was before him in Sacramento that would have said that parents must be present when the police interview their children, but he did not sign it, and therefore it is not the law, which means that police can interview your child without you there, which of course is unfair for many reasons. Obviously, the police are trained and your children are not, but they can. So the next question we get asked is, the police just arrested my son and took him to the police department. What is going to happen now? Well, the police have power when that happens. They can either decide after interviewing your son to charge him with a crime and release him to your care pending the court hearing, or they can detain your child. That means they don't go home to you. They go to juvenile hall, and they sit in juvenile hall for 2 or 3 court days until they go to court for what's called a detention hearing. That would be a good time to hire a lawyer to represent your child, because for 35 years we've been defending juveniles who are accused of crimes and fighting to get them out of custody. At the detention hearing, the judge will decide whether your son or daughter stays in jail pending the future court hearings and the trial, or whether they come home to you pending the trial. That is a tremendously important day in the case, because if your son is in custody or daughter through the whole case, it can literally be several months that he's in jail. What does the court consider in deciding whether to release your child to you? Number one, do you have a plan to supervise your child 24/7 pending the trial? So if you have 2 parents that work and your son is free to roam around the community in the afternoons, the judge is likely not going to release him to you. So you would have to have a plan that you'd work with our law firm to create so the court can be assured that your son or daughter will be supervised so he can't get into any more alleged trouble. Of course, your son or daughter is presumed innocent for the entire case except for the decision the judge makes as to whether to detain your child or not. The next thing that is of extreme importance is, will your son or daughter be tried as a juvenile or tried as an adult? And I cannot stress the importance of this to your son or daughter's future. If your son or daughter is tried as an adult, it means that he faces the same consequences as if he was an adult when he committed the crime. The whole purpose of juvenile court is described as a court that wants to rehabilitate and help minors. The whole purpose of adult court is to punish people that commit crimes. So it should be relatively obvious that you don't want your son or daughter in a system where the purpose is punishment. You want your son or daughter to be treated as a juvenile, where the juvenile court will try to rehabilitate that person. So how is it decided? Well, up until November 2016, the district attorney's office could decide on its own to decide to try your son or daughter as an adult, and nothing could be done to stop it. But luckily, the voters of California in November passed Proposition 57, which now says the district attorney's office no longer has that sole power, and the decision has to be made by a judge. The judge will hold what's called a fitness hearing. It is, again, critical to have our law firm representing your child at a fitness hearing, because the judge has final say, and the judge looks at 5 different criteria and decides whether or not your son or daughter should be tried as an adult or a juvenile. If the court looks at that 5 criteria and decides your son or daughter should stay in the juvenile court, you'll be very happy, because that means his maximum sentence is less. It means we're going to try to rehabilitate him. If the judge says, no, you're going to adult court, and let's say it's a murder case, your son or daughter, who might be 16, is facing 25 years to life. That is a very serious potential punishment. The court looks at several criteria. They look at how sophisticated the crime was. They look at your son or daughter's prior experience in the juvenile court. Does he have any prior crimes that he's been convicted of? They look at his entire social background and many other factors to make that decision. So that's how that works. And if your son is tried as an adult, everything is worse except for one thing. If he's tried as an adult, he has the right to a jury trial. That means all 12 jurors have to agree on your son or daughter's guilt. That's not that easy in most cases for 12 people to agree, because 12 people don't agree on many things. But if your son is tried as a juvenile, there is no right to a jury trial. He would be tried by a judge. And most judges have heard it all in the juvenile court, and they are the final arbiter of whether your son or daughter is guilty. So it's obviously much easier to get a conviction in juvenile court with one judge deciding than in adult court. But other than that, you would never want your son or daughter to be facing adult charges. Another critical thing to know is if your son or daughter is charged with a misdemeanor, which is the vast majority of cases that we handle in juvenile court, there is an option if your son or daughter is basically a good kid and committed one petty theft, for example, or might have stolen a bike or done one silly criminal act. The probation department has the power, once your son is released back to you after the police arrest them, to try to handle the case informally. And in that case, you go to a meeting with your lawyer and the probation department, and you try to reach an agreement with the probation department that your son or daughter should be diverted out of the court system and to take some classes, and that means it doesn't end up on his record and he has no other consequences. So a very, very good piece of advice is if your son is arrested for a misdemeanor, you should contact our office right away so we could try to work with the probation department to have his case or her case handled informally and not through the process. When your son is actually prosecuted for a crime in juvenile court, unfortunately you must appear, one parent must appear at all court appearances. Of course your child has to appear, and some of these juvenile court cases literally can go on for a year. That's many days off work for the parents. The parents are very unhappy at their loving child, and the child ultimately could do community work service, he can do time in juvenile hall, but let me assure you, it's a lot better than being tried as an adult. I hope this information has helped. Please spread the word about the things I've told you today, and please teach your kids the best you can to not piss you off by having them get arrested. Have a great week. Bye.